Okay.
We are live streaming now, yes.
Okay.
Okay, thank you. Hello, our viewers. I welcome you all on behalf of the Department of History, University of Delhi, to another exciting lecture. I am really glad to introduce our today's speaker, Dr. Hayden Bellenoit, who is an associate professor of history at the U.S. Naval Academy at Annapolis. He completed his DPhil in modern history at Oxford University, focusing on modern Indian history. His first monograph, Missionary Education and Empire in Late Colonial India from 1860 to 1920, which was published in 2007, he explored the religious and epistemic encounters between Indian students and missionary teachers in United Provinces. Dr. Bellenoit's second monograph, The Formation of Colonial State in India, Scribes, Paper and Taxes, 1760 to 1860, was published in 2017. He explored the social and cultural history of various Hindu penmen, Kayasthas, and how their occupational histories and fiscal knowledge provided the motor for the emergent bureaucracy of colonial state. He has authored articles in modern Asian studies and South Asian history and culture, recently publishing an article about Kayasthas' legal divigya status in the later 19th and early 20th century, flesh, booze, and contested lineages. Dr. Bellenoit has very personal connection to India, having met his wife in Delhi and married here in late 2008. He is speaking today on the topic legal limbo and caste consternation, determining Kayasthas' varna rank in Indian law courts from 1860 to 1930. Thank you, sir, and please go ahead, sir.
Okay, and thank you for that very kind and warm introduction. How much time do I have to speak, if I recall?
Yeah, you speak for 1 hour,
1 hour.
Wow, okay.
Yeah,
Okay.
please. The whole evening for us here is dedicated to you.
Okay, okay. I hope not to disappoint. Okay.
No.
Well,
I'm sure it's going to be a great, fun for us, in fact.
very good. Thank you. So
Okay.
I hope I'll make it worth everyone's while. So the paper I'd like to deliver today is, as mentioned, it's titled Legal Limbo and Caste Consternation, determining Kayasthas' varna rank in Indian law courts, roughly 1860 to 1930. So I'll start with the introduction. In 1889, the Kayastha Sabha, which was an umbrella organization in North India, issued a resolution declaring Kayasthas to be of Kshatriya descent and, by extension, twice-born, Dvaj. 15 years later, Kumar Chedda Singh Varma, who was a moderately well-known advocate at the Allahabad High Court, published a suggestively titled treatise, Kshatriyas and would-be Kshatriyas. Now, intensely familiar with their predominance in the sinews of the city's municipal administration, he noted how Kayasthas regularly claimed a Kshatriya lineage since the 1877 work by Munshi Kali Prasad, the Kayastha Ethnology, and hoping for an inkling of sympathy given their sheer numbers in the administrative fabric of North India. Varma quickly disappointed by saying, quote, "In the eyes of the law, Kayasthas are nothing more than Sudras." Now, Varma's judgment, while trite, was not actually an uncommon one among higher caste advocates and legal scholars at the beginning of the 20th century. For despite being a very well-placed service caste that shaped the middle-tier bureaucratic contours of the late Mughal period and the early sort of colonial state, Kayasthas had been in a remarkably defensive position since the 1870s about their caste rank, both from Indian and European authored colonial ethnographies, which tended to largely assign them a Sudra origin, combined with also losing ground in securing state employment and competition in North India, particularly among upwardly mobile Banya and North Indian Brahmin families. So there was a palpable sense of anxiety that gripped Kayastha advocates, public servants, and reformers over the last few generations of the colonial period. Now Varma's quip, however, I think offers a window into a largely unexplored relationship between law and the construction of caste categories in colonial India. And so this paper aims to show how a social group with a hitherto fairly ambiguous caste and varna ranking interacted with colonial law in the construction of these very varna ranks. So it looks at a series of rather unextraordinary local inheritance disputes to aim to offer fresh insight into how colonial law intersected with changing notions of caste and varna hierarchy, and whether laws shaped or reflected changes in Indian society at the time. Now, I think it's fair to say that Indian legal history has done very well in historiography to shed light on colonial law's construction and the role in the construction of religious communities and categories. And I'm thinking particularly the work of Nandini Chatterjee, Mitra Sharafi, and Julia Stevens. But I think it's fair to say that less attention has been paid to law's role in the construction of actual social and caste categories. The only work that's kind of nudged us in this direction has been by Ritu Burla, who has demonstrated how Marwari families navigated a fairly intrusive legal economic framework to fashion themselves fairly successfully as respectable, quote unquote, family firm enterprises compatible with modern colonial workings of capital and markets. And so what this paper aims to do is to build upon Burla's work by shedding light upon a largely unexplored aspect of Indian legal history, and that's how North Indian Kayasthas sought to achieve a twice-born ranking within the colonial law courts between 1870 and 1930. It tries to to show how colonial legalism, which tended to favor high dharmashastric notions of Indian jurisprudence when it was convenient and ultimately enforced by case law, helped construct Varna as a social category that Kayasthas were invariably forced to engage with, whether they liked it or not. And so in doing so, this paper aims to utilize Mitra Sharafi's notion of, quote, the traffic between law and identity by exploring how contestations over what actually constituted Dvaj or twice-born rank intersected with Kayasthas' interactions with the colonial legal system. And in doing so, this paper also aims to fill gaps in more well-known works on caste construction of colonial India, mainly the work by Nicholas Dirks and Susan Bailey, by actually exploring how one arm of the colonial state, that is law, actually categorized and constructed Kayasthas' caste rank. And so methodologically, this paper approaches law and caste by threading together multiple legal suits that involved Kayasthas' inheritance disputes that referenced twice-born as a category upon which cases would be adjudicated. A predominant feature of the scribal and secretary classes in the late Mughal and early British colonial periods, it's fair to say Kayasthas historically possessed a fairly ambiguous caste rank. And the paper goes on to proceed by examining these several regional inheritance disputes and to examine how Indian jurisprudential and courtroom argumentation over what actually constituted this rank by looking at whether it was contiguous rituals, life rites, samskaras, contemporary occupation and history, inheritance practices, or lineage. What were the determining factors that actually constituted Varna rank? And this paper also explores the different types of varying evidence that were used in the colonial courts. For example, references to Sanskritic jurisprudence, both the Mitakshara and the Dayabhaga sort of jurisprudential schools, so to say, colonial ethnography, the Vyavasthas or Pandits' legal opinions and reasonings, and particular forms of expert witness testimony. And so what this paper argues is that courts in colonial India, which tended to adjudicate inheritance disputes based on either a Dvaj or non-Dvaj rank, this might have seemed very powerful, but when you scratch the surface a bit more, law's ability to construct caste rank was very inconsistent, very provincial, and actually subject to molding forces in Indian society. And in fact, in many cases, the legal arm of the colonial state was remarkably uncoordinated in its ability to adjudicate Kayasthas' Varna rank during the very heightened era of caste reform movements before 1920. So I'm going to start by mentioning, I'm not going to go too much into the real very weedy specific details of the cases. I'm going to give more of an overview of them. But some of the earliest sort of cases we see that deal with Kayasthas and sort of their and what their sort of Varna rank is. First one actually emerges in a very sort of Zilla level dispute in 1861 in the Ghazipur district. And this the case is called Musammat Radhe and Har Narayan versus Musammat Rukim and Lakshmi Narayan. And this is what involved the Kayastha family, and in particular individual Kayastha named Sungam Lal. So he died, and he left behind both his concubine, Musammat Radhe, and his legally recognized wife, Musammat Rukmin. Now, both ended up claiming Sungam Lal's estate, And the case was taken up by Ghazipur's Sadr Amin, Molvi Muhammad Habibullah Khan. And what's interesting about the case, it was noticeable for being one of the first in North India that indirectly queried Kayasthas caste rank. Now, Habibullah, clearly no expert in the Dharmashastras, he actually sought legal opinion from the court assigned Hindu Pandit, who was assigned to the Sadr Divani Adalat. And what's interesting is when you read it, the translation of his vivasta, his legal opinion or reasoning, started actually with a very unambiguous declaration, quote, Kayasthas are not Sudras. And so this is a fairly unremarkable 1861 case, and that was really the end of this case in terms of the actual sort of documentation of the proceedings. But this 1861 case was followed up in 1878 with a suit that actually further probed and interrogated Kayasthas' legal varna rank in another inheritance dispute at the Divani Adalat sort of level. And this case involved was called Harak Jai Manga versus Musammat Subda and Olopa. Now, what's interesting is that this suit actually revolved around the question of whether a technically illegitimate son could claim an equal share of his Kayastha father's estate. And it actually involved this Vivasta Kayastha named Shiva Charan Lal and his estate of about 3,479 rupees in 1878 money. Now here, the plaintiffs, Harak Jai Manga, demanded equal shares from the estate, claiming, in fact, that Kayasthas were Sudras, which guaranteed equal shares for adopted sons, with under the legal reasoning that, according to the Mitakshara sort of interpretation of sort of the Hindu family, that surviving widows could only claim maintenance. Now, the subordinate judge of the Kara district where it took place, Molvi Fariduddin Ahmad Khan, basically worked under the assumption that Kayasthas were Sudras. Now, the defendants, Musammat Subda and Olopa, took a very different approach, actually. They aimed to prove their twice-born rank and obviously avoid paying out based on Sanskritic legal and Puranic treatises. And after poring over various Dharmashastric treatises and various major and minor Puranas, one of which they referenced quite regularly was the Skanda Purana, the officiating subordinate judge, Mirza Abid Ali Beg, ended up dismissing the case, ruling that Harak and Jai Mangal lacked standing to demand equal inheritance, because in Beg's opinion, Musammat Subda was clearly twice born, and to him, this invalidated Jai Mangal's claim to equal share of the inheritance. So what this case actually did is reaffirmed the 1861 Ghazipur decision, but started to push what I would call the probing and the interrogation of what actually constitutes sort of varna rank in the eyes of the courts a bit further. Now, in pre-1880 North India, there were a number of these local run-of-the-mill inheritance cases that informally kind of affirmed an implicit legal opinion that Kayasthas were Dvaj, twice-born. But what's interesting is when we shift to Bengal country in the early 1880s, we see a noticeable change in both the legal opinions and the nature of the evidence brought to bear in front of the judges. And there's one particular case that was brought before the Calcutta High Court in 1884 that significantly complicated Kayasthas' all India claims to be twice-born. And it involved another dispute, actually not involving Bengali Kayasthas, but Bihari Kayasthas from the Chausa district, involving one Rajkumar Lal and his 4 sons in an adoption case, which was called Rajkumar Lal versus Bisasur Dayal. Now, this 1884 Calcutta case is interesting because it's a bit different. What it seemed to sort of, when you read sort of proceedings of the case, it seems to largely privilege the Indian Bengali legal scholar Shyam Charan Sarkar's very influential 1867 legal work, the Vyavastha Darpana. And the High Court here seems to have been very much swayed by the prominence that samskaras and continuous living ritual are the elements and the ingredients that actually define one's varna rank. And so the justice at the time wrote, quote, there is a preponderance of authority to evince that the Kayasthas, whether of Bengal or any other country, were Kshatriyas. But since several centuries past, the Kayasthas, and these made a very specific point, quote, at least those of Bengal, have been degenerated and degraded to Sudradam. So you see the justice here took a really, really fine sort of historical interpretation of the longer histories of Kayasthas over north and then eventually into eastern India. And then after delving into contesting debates over whether Kayasthas actually donned the janao, the janiv, the sacred thread, as a marker of twice-born rank, the two justices on the High Court, Justices Field and MacDonald, argued that because Kayasthas in Bengal displayed a marked inconsistency in ritual, custom, samskaras, they argued that Kayasthas cannot, quote, upon the evidence of these observances, rank among the three superior classes. So what we see is that these cases in North India were severely complicated by an 1884 Calcutta High Court case, even though it didn't involve Bengali Kayasthas, it actually involved Bihari Kayasthas. And because this was such a big sort of High Court decision, it made regular references within Kayastha publications, mainly the Kayastha Samachar, later the Hindustan, later the other sort of Kayastha sort of publications. It was cited very frequently as a cause for action for Kayasthas to legally be recognized as twice-born. And then we're going to see how this later shifts into the Indian census. Now, when you get to 1926, though, we see a very interesting case because by the late 1910s, there was kind of an unstated jurisdictional jockeying between the Calcutta and Northern Indian courts that really vexed Kayasthas' attempts to be legally recognized as twice-born. But things changed after 1905 with the partition of Bengal, because now that Bihari Kayasthas were no longer subject to the jurisdiction of the Calcutta High Court, now subject to the jurisdiction of the Patna High Court, very different dynamics actually played out. And we look at one case from 1926 that originated from a 1922 Gaya district suit called Ishwari Prasad versus Rai Hari Prasad Lal. And in this suit, what was really interesting, the question involved the question of whether adopted sons of twice-born Hindus could claim inheritance. Now, this case worked out very differently from the 1884 Calcutta High Court decision, because unlike that decision in the 1880s, Sarkar's very famous sort of Vyavastha Darpana came under a lot of scrutiny by Justices Field and Justices Jwala Prasad. And we have to give the disclaimer that Justice Jwala Prasad himself was actually a Kayastha, even though it wasn't mentioned in the legal proceedings. Now, the two justices made a clear distinction, which they argued that the Calcutta High Court failed to do. They distinguished between the different rituals and samskaras of Bengali and Bihari Kayasthas. Justice Jwala Prasad was unsurprisingly, perhaps, much more skeptical of what he argued was Sarkar's more quote-unquote Brahmanical reasoning. Justice Prasad argued that Sarkar failed to make the real geographic and cultural distinctions between Bengali and Bihari Kayasthas. And what he also did, Justice Jwala Prasad, he also downplayed the role of ritual and life rites, samskaras. And he argued that, quote, it has been accepted without any controversy that the status of the Kayasthas as belonging to the twice-born caste has been accepted in these provinces. So what you tend to see here that in the 1926 Patna High Court case, a very, very different emphasis that's more upon, less upon samskaras and living continuous sort of ritual affirmation, and more on general sort of what we'd say occupational reputation. But in the end, the case involved was actually resolved through an amicable settlement. Rai Hari Prasad relented, agreeing to give property to Ishwari Prasad worth 1,000 rupees annually. And while it was not an official adjudication of Kayasthas' Varna rank, Justice Prasad's opinion was unambiguously clear that Kayasthas were twice-born. And he actually even does go into a lot of citations of various colonial ethnographies, mainly Munshi Kali Prasad, and also Denzel and William Crook as well in his ethnography, that kind of sort of both implied and said very clearly that not only were Kayasthas twice-born, Devaj, but that they were Kshatriyas. So there's a lot more like fine-combed sort of like, I guess I'd say, sort of like surgery in terms of like an autopsy of sort of the colonial ethnography in this case compared to the 1884 case. But when we step back and we look at the broader picture, we tend to see that the very provincialized nature of law in colonial India with different provincial high courts and actually no central legal sort of court to adjudicate all India disputes actually prevented Kayasthas from achieving any consensus regarding what their legal varna rank was. Perhaps ironically, Kayastha litigation to be recognized as twice-born had the effect of actually undermining their efforts. For some Kayastha parties, it was actually in their interests in terms of property and material sort of benefit to actually be ruled as legally Sudras. And for others, it was actually the opposite. So these wildly inconsistent rulings between Patna, Calcutta, and Allahabad demonstrated this very clearly. And these rulings, importantly, had a real effect upcountry upon North Indian Kayasthas' social lives, and they had a real social life. And this is why the court cases attracted so much Kayastha publicity and rippled through the social fabric of North India. Regularly, this Kayastha Samachar actually referred to the 1884 ruling as a, quote, shock to the community and a call for action. But beyond that, it seems that since litigation, perhaps ironically, litigation actually made it harder for Kayasthas to close rank and achieve the legal ruling and adjudication that they sought. So what they started to do, particularly after the 1910s and 1920s, is they started to shift from litigation to lobbying, and they saw the Indian census as an alternative space where some form of official recognition could be secured. And this was a very significant shift from litigation to lobbying. Because since the census, for example, was not subject to similar litigation, Kayasthas could make a more manageable and controlled approach, and they put a great deal of efforts to get listed as twice-born in both the provincial and the all-India colonial census, particularly the last tricennial all-India census of 1931 before independence. And it's here that we see legalism and the colonial state's tendency to taxonomize and organize kind of intersect, I think, in very novel and unexplored ways. And I'm just going to go through one main example of what you see, particularly running up to the 1931 tricennial census. In 1930, the chairman of the Mirut Kayastha Sabha, Chamandar Prasad, he wrote to the All India Census Department a fairly telling letter. And he referenced the 1889 and 1926 legal cases in Allahabad and Patna, respectively, that affirmed that Kayasthas were basically twice-born. But what he did is he took this approach further. And he noted that in his correspondence, a kind of charitable nod to Kayastha ecumenicalism, referring to the Kayasthas of Bengal country and the Prabhus of Western Maratha, sort of Western India. He actually, though, explicitly excluded Bengali Kayasthas from his correspondence. He then pointed out that there was a census plan to register the subcastes of Brahmins, Kshatriyas, and Vaishyas, basically underscoring traditional Dvaj, Jati, and Endogamy. And he argued that this whole idea was flawed because it didn't include for Kayasthas. He wrote to the census commissioner, William Burns, that, quote, the Chitragupta Vanshi Kayastha cannot but insist on their subcaste details being similarly recorded, basically arguing that because Kayasthas considered themselves twice-born, their jati, endogamy, and subcaste should be recognized similarly with Brahmins, Kshatriyas, and Vaishyas. He also argued that more inquiry was needed to ensure that others could not pass for Kayasthas, particularly what he argued were certain sort of laboring communities in Bengal who tended to attach Kayastha to their surname in the hope of upping their rank in the colonial census. And he argued that the Census Commission should police this very intensely because it would, quote, affect the census statistics and dignity of Chitragupta Vanshi Kayasthas, who, as he emphasized, who are Kshatriyas. And perfectly reflecting how colonial legalism and colonial taxonomy cross-pollinated each other, Prasad referenced the 1926 and Patna High Court case and the 1889 Allahabad High Court case to basically vindicate Kayastha claims to twice-born status. Now, what I'd like to do, I think maybe in the last 10 minutes or so, is just offer a conclusion. Now, what this paper has attempted to do in a very kind of shorter, sort of more brief form, is to kind of explore some of the few novel and unexplored ways in which caste was constructed through colonial law courts, particularly by looking at case law. It has argued that by threading together various property disputes involving Kayasthas between high courts in Allahabad, Patna, and Calcutta, we can actually gain fresh insight into the role colonial law played in the construction of caste categories. For Kayasthas, they had to prove to judges that their customs, occupations, and lineages were decidedly twice-born. But a close reading of the various cases indicates actually there was no consensus as to what actually constituted Dvaj or twice-born rank, both among Indian society and among justices themselves. Courts had great interest, obviously, in assigning varna as a tool of social stability and for expediting legal adjudication. But colonial courts, we can see, if anything, produced a fairly inconsistent body of case law, which was ultimately unable to fix Kayasthas' varna rank. And I think here it's probably helpful to reference some of the existing scholarship on caste. I mean, it was a long time ago, but Bernard Cohen once, for example, a long time ago emphasized law's ability as a, quote, instrumentality of colonial rule in creating more rigid caste categories. But I think when we look a bit more closely at the legal evidence and the case law, I think colonial law looks a bit less powerful and if anything, a bit more inconsistent. And when we look more at also the work by Nicholas Dirks and Susan Bailey, for example, have both argued that colonialism in varying degrees shaped modern conceptions of caste. I think it's fair to say that both works have largely overlooked the role of law in these processes. And so this paper, by shedding light upon caste's, what I would call legal archive, this paper has sought to make a novel contribution to our historical literature by looking at one particular sort of caste group, Kayasthas, who haven't received a lot of attention within the historiography of caste in colonial India. And debates over what actually constituted twice-born rituals and purities, while they undoubtedly were raging by 1900, case law actually did little to settle the matter for Kayasthas. And I think perhaps to put this in perspective, I'd like to reference the work, a recently published work by Nandini Chatterjee, who has recently made the argument that law in Indian history has largely been used to evaluate the power of the state. And I think that's a fair assessment. And I think this paper has perhaps inevitably kind of done that. But in doing so, it's also sought to draw attention to the novel ways in which colonial law intersected with the construction of caste and varna identities, and particularly how it spills over into another arm of the colonial state, that is sort of the census and colonial taxonomy. Since the high courts of Allahabad, Patna, and Calcutta offered no consistent case law, in a way, in retrospect, the census became Kayasthas' almost best and only hope for an official twice-born recognition. A long time ago, there was a scholar, Richard Samras Smith, actually once hinted at a connection between caste as a governing category, what he called rule by record, and the census, arguing for the utility of caste for administrators once it became regularly documented in the census. And I think this paper has shed light upon this very transition and its connecting sinews, arguing that the census reports at the all India and the provincial level reflected the law's uncoordinated ability to assign varna rank. The structural and jurisdictional inconsistency greatly informed the taxonomy of caste, particularly in the tricentennial censuses after 1901. And when you look very specifically, the Bengal volumes bore the imprint of the 1884 Calcutta rulings, while the Northwestern Provinces and Bihar volumes reflected the more quote-unquote successful rulings in Allahabad in 1879 and Patna in 1926. And I don't have in my paper here, but I can remember very quickly that, in fact, at the Bengal volume, the Bengal provincial volume for the 1931 All India Census, the Bengal volume actually makes it very clear and references the 1884 Calcutta High Court case. That makes it very clear that in the province of Bengal, Kayasthas have largely been assigned a Sudra rank and are legally sort of recognized as such. But what's interesting is when you get to farther up country, for example, the Bihar volume from 1931, you tend to see Kayasthas, well, Bihari Kayasthas don't get an official stamp of approval for being twice born, but they are listed with literate and highly placed service castes, namely Brahmins and various Rajputs. And when you go to the north, to the United Provinces, Uttar Pradesh, it's even more clear, actually. What you see there is that Kayasthas are linked, are actually sort of, they're actually listed as one of the quote unquote interior castes up there with the varnas of Brahmins, Kshatriyas, and Vaishyas. So it's actually in UP where they actually get a more official ruling. And what you see is that the census returns in 1931 tend to largely reflect those varying sort of provincial different legal rulings between Bengal, Bihar, and UP, for example, okay? And I think it's fair to say here that when you look at this a bit more closely and a bit wider, at a wider angle, I think we see, at least we're talking about civil law, not criminal law, we see less, what I'd argue, of a legal despotism, and I think more of a very chaste legal culture that's really unable, I think, and also kind of unwilling to assign the literate and highly placed Kayasthas a definitive varna rank. And I think it also largely reflected the pulse of debates in Indian society itself during this reform period of what actually constituted varna rank. Now, colonial law undoubtedly created new legal norms and categories over which Indians and Kayasthas had little control. But I think it's fair to say that in the case of caste, the legal opinion on varna opinions were inconsistent when it came to ranking a supposedly quote-unquote essential quality of Indian society. The court's rulings were contradictory, contested, and I think above all deeply provincialized. And Kayasthas' arguments, coupled with barristers, judges' opinions, complicated it even further. And I think this brings us back to the broader interplay between caste and colonial law in Indian history. And again, I'd like to reference the work by Ritu Birla, for example, who has demonstrated, I think very convincingly, how Marwari families successfully position themselves within colonial law as quote unquote legitimate economic actors and bearers of modern sort of capital. And I think here there were parallels, but albeit in a very different context. Unlike Marwaris, for example, Kayasthas' varna rank was, I think it's fair to say, historically far more ambiguous, since it was subject to more roundabout litigation and contest, hence why it was subject to much more roundabout litigation and contestation. And then moreover, Kayasthas were somewhat less successful, quote unquote, in engaging the colonial legal system, unlike Marwaris. The provincialized nature of colonial case law, Calcutta in 1884 compared to Allahabad in 1889 and Patna in 1926, rendered a definitive Dvaj rank elusive. I think ironically, Kayasthas achieved much more success not through the courts and litigation, but through lobbying and the colonial census. And I think this raises interesting questions for future research about the ability of social groups in India to utilize colonial law for social and caste advantages. And the limits of provincial jurisdiction complicated this further. As we know, for example, before independence, there was no central all-India court to adjudicate these matters. That only came after independence. And I think the limits of this provincial jurisdiction, this legal limbo that's in the title, I think, this consternation over where do we actually rank people in Indian society from a legal standpoint, I think to some degree it actually informs independent India's more Nehruvian socialist decision in 1951 to cease the collection of caste census data, save for that of Adivasis and untouchables. And I believe actually, though, the census, that data was actually collected in, I think, in 2011 or 2014, but hasn't been released. So this is, in a way, coming full circle, perhaps, or so. But in sum and all told, this paper has attempted to not only shed light on the value, I think, of the legal archive for our historical understanding of caste construction and rank, but I think also to raise important questions about the ability of colonial law as one arm of the colonial state to shape Indian society and its supposedly quote unquote timeless and essential unquote social categories. And I think that's it's a bit shorter, but I think that's going to be all for my paper today. And I think, as always, usually the questions and the answers are far more fruitful and richer than the actual paper itself.
Thank you very much, sir. Thank you very much. And now in this session, second session, the floor is open for our participants to please put up your questions. And if there are any questions,
I think Professor Akil is trying to say.
Sir, your mic is okay.
Yeah.
Okay, go ahead.
Sure.
Okay.
No, this was very interesting, and maybe when our participants are articulating their questions, let me thank you for this presentation. And in fact, we were gearing up for listening to you more in terms of further complexities with regard to these kinds of identities, which were, sort of created, the caste identity and religious identity in the manner in which it happened. You mentioned census and all that. So I was just thinking, as someone who works from the pre-colonial period or pre-modern period, I was thinking, what were the situations like in terms of the status of these people, the Kayasthas? So maybe some sections of the Kayastha people will be very educated. They will have learned Persian, and then they'll get into the bureaucracy as scholars and etc. And perhaps they were doing very well for themselves without anyone asking perhaps what is their varna status, so whether they are Shudra or twice born or something. It is only when the hardening of the identities of the kind that happens in the late 19th century that we see that these communities of people have to now come out and legally claim some status, which perhaps was not needed previously in terms of assertion of the identity. So, and then you are mentioning about how there are internal difficulties within what kinds of Kayasthas are there. Maybe Bihari Kayasthas are different from the Bengali Kayasthas and etc. So in that situation, what will the colonial law courts do? So there, perhaps, as you mentioned, there will be difficulties in handling the complexities and different kinds of situations. So the other set of sources that I was thinking about, how when these communities are organizing themselves, maybe they are organizing themselves into some samaj or sangatan, sabhas, and in doing so, they are also producing their caste histories, the vernacular, indigenous, local caste histories in which they will be drawing inspiration from some ancient texts claiming that they have actually descended from such rishis and munis and etc. Cross connections in terms of synthesis of caste, emergence of caste out of different varna ranks, in the sense that the varna ranks were actually continuously defied. And that's how many different kinds of communities have emerged. And those communities now needed to spell out where they stand in the social hierarchy.
Yes, exactly.
So maybe, because you have worked on all this, maybe you can speak further to enlighten us on this.
Sure, of course, yes. Thank you, Professor Akil. So there are two parts to that, right? The first part is the Kayasthas among themselves have some unofficial rankings and hierarchies, basically. What I tend to see is that a lot of the people who are leading these types of movements to get recognized, litigation, and later the lobbying, they tend to be usually either usually one of three different Kayastha subcastes, with the larger North Indian 12 Kayastha subcastes. They tend to be either Shrivastas, Saksenas, or Mathurs, for example. They tend to be, and I don't have it in this paper. I've written on this in another paper, and in my other book on Kayasthas of the colonial state, is that the Shrivastas generally tend to see themselves as one of the highest, basically, Kayasthas. I think they say, what did they say? They say among themselves, they say like Kayasthas sabse upar, sort of like we're the highest. The Saksenas tend to see themselves as like descendants of those who are like Mir Bakshis, military paymasters working for the armies, and the Mathurs also see themselves placed very highly. So it's hard to sometimes get into that, but you can sometimes tell where they're from and by their names, which subcaste they are. So they're the ones that kind of have that. There also tends to be, I've noticed among them, this unofficial ranking kind of in a way sometimes is geographical. So for example, they talk about the Karan and the Bhatnagar Kayasthas, for example, of Bihari country. And they tend to those two groups tend to be less involved, I think, in a lot of this public activity, litigation, for example, and whatnot. So that's a very important thing to bear in mind, is that the Kayasthas, they're not just a single uniform group. They have these various subcastes, for example, and they have this uninformal informal sort of hierarchy amongst themselves, basically. Because I think from what I've researched, all the subcastes, I think except for the Bhatnagars, practice like standard jati endogamy and practice and don't practice hypergamy, marrying upwards. The Bhatnagars, I've seen some evidence that they actually do try to marry upwards, but it's kind of inconsistent. It's sometimes really hard to scratch at this. But Professor Akhil, I think your second point about what are they doing to brandish their image, that actually goes into the other paper I just published this on flesh, booze, and contested lineages. There's a lot of, it's part of this like reputational, I'd say, salvage operation, because Kayasthas are coming in for more pointed critiques. And actually one of the persons who really ruffles their feathers is Mohan Matan Malavia, for example, in UP. I mean, he's very, very clear about making public statements, both clear and coded, that, as he put it at some point, the Kayasthas, their time is up, basically, right? And they point out all these things, how they, they don't wear the janoe, for example. They don't do the proper, for example, when it comes to Antieshi, they mourn for 30 days as opposed to 10 or 14, for example. So there's a lot of like this that's going on. So what you do tend to see with Kayasthas, they're trying to like manage this reputational damage, which is partially informed, I think, also by colonial ethnography. There's a lot of colonial ethnography, for example, both European authored, but also Indian authored. And the European one, I think, for example, of Herbert Risley's The People of India, tends to sort of like look at Kayasthas as he argues in terms of a pseudo-racial science idea, that they're a bit lower in the caste rank. But there are also other very important Kayastha rebuttals to this. I've looked at a few of them. One's by Gopinath Sinha Verma as a peep into the origin, status, and history of the Kayasthas from the late 1920s. And he makes it very clear that Kayasthas are twice born, if not Kshatriya, because of their occupational history, right? They served, the sultans, they served the nawabs, now they're serving the Angrezi, and they've always been in service, basically. And I actually came across a Hindi language one that I did a bit of translating for from the Bihari Kayastha, Chitraj Raj Kishore Prasad, and it was titled Chitragupta Mahaparavira Ka Itihasa. It was actually a Hindi language thing of like, and he basically argues in my imperfect Hindi Khariboli translations that it's they aren't categorized by Varna because they're not avarna, they're not without Varna, they are beyond it. They're beyond it, basically. And so it's a very interesting like kind of take on this. And then there's the more famous, Munshi Kali Prasad, his ethnology from 1877 that makes it very clear. But what you tend to see, I think also the one thing that they're really keen on, Kayasthas, in terms of upping their perceived rank in society, with all this intense debate over social reform and stuff like that, that we know is going on in later 19th and early 20th century India, they very clearly are responding to the Bengali Pandit, Jogendranath Bhattacharya, his Hindu castes and sects of 1896, which is basically colonial Indian ethnography. He made it very clear that that at least Bengali Kayasthas, he saw, were basically Sudras, and they didn't follow the proper sort of samskaras. So they're responding to this. And one thing they actually do is they organize the annual Kayastha conference, and they move around from UP to, sometimes in Madhya Pradesh, sometimes they're in UP, sometimes they're in Bihar or Bengal. But they're basically trying to publicly encourage Kayasthas that, for example, when you're doing Antieshi, you should not mourn for 30 days. They tell them very clearly, you should do 10 or 12 or 14 days, okay, to be more what they consider Dvaj, for example. The other thing that they also do that's very public is, and I don't want to go into reputations too much, but they actually do a lot of policing of the reputation of Kayasthas with sharab and booze, basically. So one thing that they are at the Kayastha conferences actually very clearly try to police is to tell Kayasthas, at Holi, like, don't go PKI, don't do like crazy stuff. And they're trying to police it very clearly because it's a very public thing. That's right. So you start to see what they pass along at the annual Kayastha conferences are what they call these chittis, basically, right? It's like pledges. Don't abstain from, wine, sharab, or at least they say, I think in one case they actually say, if you're going to drink, you should drink dudia, which is like country wine, basically, right? Something that's more deshi, basically, rather than something imported. And they do seem to actually, they actually come up with it's called a Kayasthas Drink Destroyer Society. Their slogan is Pani ki jai, sharab ki jai, like victory to water, defeat to wine. Like they're doing a lot of this. And I think this actually relates at a broader, like reverberative level to the cases that are going on in the courts, even though they're not directly cited. There's like this reputation that has to be managed and sort of, I think to some degree policed. So the annual Kayasthas conference, the Kayasthas Samachar, for example, this publication in particular, and whatnot, and which would become later the Hindustan Review, most of the editors, obviously Kayasthas, and they're constantly referencing the court cases, 1884 in particular, 1927. So that it has a social life, and they're really talking about it and whatnot. So there is a big life of that, and they are doing things. The only thing where they are not successful, they make good headway, the Kayasthas annual conferences, in terms of getting this outward sort of teetotaling, right? Like drinking less. But when it comes to non-vegetarianism, forget about it. It doesn't work at all, basically. They admitted that the vegetarian was, quote, neither nor so popular nor successful. They actually tried to send along at the Kayasthas annual Kayasthas conferences gosht chitis, pledges not to take flesh and meat, and it doesn't work basically at all. So I see, and because it's also, I think, punctuated within colonial ethnography and reputation. There's one colonial piece by Robert Vane Russell. He notes that Kayasthas, quote, continue to eat the flesh of goats, sheep, fish, and birds. This is really hard to sort of get around, basically. But yeah, Professor Akhil, it's a very good question, because there is a larger social life that one can go into, you're right. And I think it's loosely like in the background shaping these court cases. I think it would be very interesting to look at how they connect with each other, talking about non-vegetarianism, these, samskaras, and how they sort of more specifically come up in the court casings. But thank you. Those are very good questions and observations.
So a couple of questions have already come in the chat box, and I'm sure more people will be interested. But if I can quickly say one more thing, which is related to what you are talking, in terms of the state, in this case, colonial state and the law on the one hand, and customary practices which are giving particular identities to these tasks on the other. And therefore, post-colonial, as you said, the Indian state will be coming up with a law which is going to be common, a Hindu law code, going to be common for all Hindus. And then there are certain communities which will have their own personal laws. But now there is a debate in our times about the need for a uniform civil code. If a uniform civil code is brought in, what will happen to the identities, particular identities of these different communities or castes, jati, people? How will they be governing themselves in terms of their distinct customary practices? When a uniform civil code, whatever may be the thrust of that, there are apprehensions about that. Apprehensions, especially say in Muslim communities, for instance, that a uniform civil code is going to completely do away with Muslim identity. And there's no one Muslim also, as you know, that there's no centralized Muslim authority governing Muslim customary practices either. So when states, make laws, sometimes not taking cognizance of the customary practices and long traditions of particular communities, then the law gets into difficulty in terms of implementation. And then this leads to further need for reform, either from above or from below. And law must be made from below, perhaps, in terms of the changing times requiring reforms and changes, and for which law is needed sometimes, isn't it? So maybe you can respond to this, and then questions in the chat box.
Sure, absolutely, yes. I should say, though, I don't want to wade too much into contemporary political debates in India. It's not my job, but I do see in a way that, debates over the Uniform Civil Code, for example, I kind of see them as kind of the inevitable grandchildren of these debates and these ambiguities that were going on, actually, I think, in colonial India, because all states, in a way, most modern nation states tend to privilege a uniform set of laws that applies to everyone, basically. And I think because there's a lot of ambiguity, and I think through this paper, you see that there's, if you're going to have a law, and you're going to adjudicate it based on a varna rank, first we have to know what it constitutes that varna rank and where do these people fit in it, right? So I think these ambiguities aren't really, I think they're inherited by the independent Indian state, and Nehru. I think they're, and they don't touch it, I think, or they touch it to some degree, but I think these debates today are still the grandchildren of like these great grandfatherly and great grandmotherly debates that were going on in the late 19th and early 20th centuries or so. It just raises a very important question about what is the nature of the relationship between law, a modern state, and people's identity. It's just something, and it's not an easy one to resolve. I know it's even in America, it's not that it's still going like that. So yes, but there's a good observation. Thank you, Professor. Yes.
Okay, Kajri, please go ahead. Go ahead, and then I'll take up question from Facebook.
Am I audible? Good evening, everyone.
Yeah.
Yes. So actually, I had two questions. That was I written down all the cases and everything, but the first question is in terms of social mobility. When we're looking at the Kayasthas through these court cases, isn't it a really small sample size? Because when we look at the evidence, the data you've shared, and I agree with you, it's definitely not like, colonialism. I mean, Susan Bailey's arguments and all of that, it's not like they didn't have any impact. But when it comes to actually allowing social mobility, I mean, how much do you think in the contemporary society of the 20th century did these legal judgments, which were very few, influence that? The other question is actually related to the early modern period, when there is another way of acquiring social mobility. That is, Kayasthas especially got a lot of titles from the zamindars they were under. And I'm sure even when the British sort of sets in, they do continue to get such titles. Now, are these reflected in, some of your data? And how did these influence within the Kayastha community? I mean, how did that influence their hierarchy? Thank you. That's it. I hope I was able to articulate.
No, that's good. Thank you, Kadri. It's an important question, I think, because when it comes to social mobility, I think it's fair to say that the people who are some of the cases we look at, what's interesting, don't involve very highly placed Kayasthas, for example. They're not often enough, they're not like deputy assistants, deputy inspectors or anything like that. They tend to be very like, kind of middle to lower rank sort of inheritance disputes in terms of the capital levels, the amount of wealth involved, basically. But in terms of those who are at the forefront of these Kayastha lobbying efforts and the litigation, they tend to be already very highly placed. They tend to be editors of journals. They tend to be like Mondli Prasad, I think, was a deputy educational inspector at some point, I think, or so. So they're already very high placed. So I think the social mobility for them is a moot point. It's just not really important for them. But I think you're right. Historically, that is one way they were able to become mobile. And I know it's a very broad sweeping statement, but it's fair to say that a lot of the Kayasthas, particularly the higher placed ones, or the ones that see themselves as more highly placed, were the ones who tended to learn Farsi. For example, they worked for the sultans, the nawabs, the mughals, for example, usually at the middling levels. But I think that's a point that was brought up by Professor Akhil before. I think before the 1840s, 1850s, 1860s, their rank didn't matter. It was kind of irrelevant to administration. The sultans, mughals, Muslim nawabs, they didn't care about this stuff. They really didn't care. But I think colonial law and colonial ethnography cares. They make it a point to go into it. And I think you see some very interesting regional dynamics, for example. So we see, for example, that I think in northern India and eastern India, Kayasthas tend to be much more defensive, I think, when looking at it. But I think this is one of the questions that came up in the chat from Facebook. When you get to Western India, the Maratha regions, for example, the Prabhus, for example, the Prabhu Kayasthas, in a very different sort of situation, because they are actually very much earlier. I think Polly O'Hanlon has written on this in Western India, that the Prabhu Kayasthas are under like a 17th century microscopic scalpel by various like Brahmanical like treatises and commentaries, basically, kind of, and that's already going on. And what I've seen with the Prabhu Kayasthas, actually, when I looked at the sort of, I have some leftover notes and some research from the what I'd call the non-vegetarianism and booze debates. The Prabhu Kayasthas actually they teetotal very quickly. They transition in very quickly. They tend to be vegetarian for the most part, so that criticism doesn't get thrown at them, I think, in a way. I think it was actually one of the one of the editors of the Hindustan Review actually says about the Prabhu Kayasthas of Western India that he says they're more Brahmanical like than our country folk up in the north, basically, or so. Anyway, I'm sorry, did that kind of get to your question?
Yes. I mean, it did, because now, but I actually had one more thing to sort of ask, that don't you think the temperance thing was an English because of the British and because at that time they were, starting the whole temperance movement, I mean, within the subcontinent as well. And I think that sort of, and I kind of understood what you said, because I think the mobility herein is within the ambit of colonialism, not exactly in society, the one that you actually argued for.
Yes. Yeah, that's a good point. Yes, the Kayasthas are looking for mobility in terms of official rank, not in terms of society, even though society is shaping and informing and putting pressure on them to actually, right. So in terms of actual rank in society, in terms of, socioeconomic status, their occupational positions, reputation, guys, these other ones are fine. They're completely fine, but when it comes to being recognized by the state, they're very sensitive, particularly to, I've learned they're particularly sensitive to Rajput criticism. Anyone who's Rajput criticism, they're very sensitive to it, because a lot of the Kayasthas claim that they're Kshatris, that they are Kshatriyas. And so that stings a bit more, basically, I think, or so. But thank you for your questions and observations. You have a lot to think about. Thank you.
Thank you.
Thank you so much.
Thank you, sir. Avijit, please go ahead.
Thank you so much, sir, for your wonderful lecture. I had one question and one slight comment to make. First, the comment. I had experienced the Kayastha Sabha culture very closely, coming from that family background. I've sort of heard about these things from sort of like an oral history or a memory from my grandmothers on both sides of my parents. And I remember them telling that Kayasthas and Bhatnagars, we have it very hard because we don't get places on rent. Other Hindus don't like us because they think that we're too like Muslims, and because we eat non-veg, and there's this culture of a Persianate sort of a culture that you have, and also in terms of the sabhas, perhaps what I've personally witnessed is a sort of reverence to Chitragupta, and you're having these, and I've heard in the family, people meeting at these massive marriage sabhas that are happening, Kayastha sabhas, where people are getting married. So perhaps this is also a colonial moment in time when they're trying to organize people around maybe Chitragupta, and through these marriage connections, and there's also history of this sort. The question is perhaps is specifically to Bengal, these, as you have mentioned, and as Kajri and other people have also said, that a lot of Kayasthas in Bengal specifically were really people who had a lot of titles, and there were zamindars. But also at the same time, in the national movement, we see that a lot of national leaders and a lot of reformers were also coming from the Kayastha caste. and specifically late in the modern time, they're also trying to like get Vivekanand and Bose and other people as symbols of Kayasthas excellence. My question is specifically is that at what point in time in Bengal specifically, when you're saying that Kayasthas are being seen as Shudras, are being classified as Shudras, does the prominence of the national leaders or prominent leaders, does that change the stance, or does that affect their perception among the larger society also?
That's a very good question, actually. I can say, I mean, I'm not completely sure. I focus mostly on like the UP area, Kayasthas in Bihar, but from what I can see, I've seen some recent work published by, her name is Nabaparna Ghosh. She's written on Kayasthas, Bengali Kayasthas. And from what I can see is that the high status of some Bengali nationalist leaders, like Netaji, for example, we tend to forget he was actually Kayastha. I think their Kayastha identity is a non-issue. It's not really very important, basically, I think. And from some of the work that I've seen on Bengali Kayasthas, their Kayastha identity matters less than their Bengaliness, I think. I think that's one thing that gets kind of like switched around, basically. I think the Bengali Kayastha Sudra rank matters more for Kayasthas upcountry than it does in Bengal, basically, I think. They're really very sensitive to this, I think, because, you know, they do in northern India, they place the bar very high, that we are Kshatriyas, you know, we are, and that's a hard one to hit for them, that they find out. It's hard to actually make that very convincing argument. Whereas I think in Bengal, this matters much less, actually, or so. Because as mentioned, you know, a lot of them do tend to be in Bengal zamindars or big merchant families. You know, for example, they have what you'd call social rank and credibility. You know, their presence, I think, you know, in society. Whereas I think, particularly when you go into Bihar and some parts of like Eastern UP, the Kayasthas are well placed, but they never tended to really be big zamindars, you know, for example, or like really big landholders. And I think that's why they always made the occupational argument that like Varna is occupation. You know, we were all the Nevisis, you know, we were doing the writing for sultans and then for like Angrezi. You know, I think that's why they always emphasize that, because that was their livelihood, I think, in a way. They didn't have the big land holdings, I think, that maybe Bengali Kayasthas did. Now, there were some, obviously, big Kayastha landowners, but on the whole, most of their material wealth tended to come through service and employment rather than, you know, very substantial ancestral holdings, basically. You know, and it's, certainly not like some Bengali Kayastha families, no. Yeah. But that's a very good point and observation. Thank you.
So there is a bunch of questions in the chat box, which almost all, yeah. They are just, can I read them?
Sure,
one by
I
one?
can. Yes, should I go ahead and read them and answer?
Yeah, they are all about this ambiguous caste or religious identity of Kayasthas. Like, the question is, Kayasthas were Brahmins who opted out from Hinduism and later were not in. If not mistaken, they were Buddhists centuries ago. Any views? And the question is put up by Ashok Narayan. It's from Facebook, sir. And then second, which is very much related, can we term the Kayasthas as Sanskritized caste who preferred upward mobility for legitimation? Question from Abhi Shan.
Okay.
And then the last question is about the legality. The legality of the status of Kayasthas in terms of foreign status has been a topic of debate in Maharashtra when Gagga Pathak was called from Varanasi to settle the claims of caste status of Chandra Senia Kayastha Prabhu community, CKP. This leads to the times of Shivaji. The question is from Ranjan Anand. Okay, sir.
Okay, so I'll start with the first one. So these, and this is perhaps, I think, if anything, an opportunity for a new type of research, is that there's a lot of historical writing and debates among Kayasthas and non-Kayasthas about their origins, I think. And this is one question, this is one historical take on it that I've heard and read about, that, Kayasthas were effectively Brahmins who basically became, Buddhists, basically, or right, became renouncers and never got back in through the door, basically. I've heard this before. It's not a common argument. I think when you get into this deeper history, it's really hard to make very definitive conclusions, basically, because it's really hard to draw those threads that transverse centuries, I think, if not thousands of years or so. I think one thing, though, that is, there's a lot of debate among Kayasthas and Kayastha critics of, for example, I think in Bengal, they talk about how the Kayasthas came with accompanying 12 different Brahmin families into Kannauj, for example, after the 800s or 900s AD into Bengal country, and that the Bengali Kayasthas trace their lineages from there. There are some who actually, I remember reading, who see Kayasthas as loosely descended. The Surajvad subcaste of Kayasthas actually claim lineage, or some people claim that they have lineage from the Shakas, the Scythians of Central Asia, basically Iranis, basically. So it's all over the map in terms of this. So I think it's really hard to say, that they were at one point this community, then they were another. However, one thing that's very consistent, I think, though, is that's probably the most constant in terms of the longer reputational position and status of Kayasthas, is that they really are the arm of, not the arm, but they're very much the deputies of Muslim sultans and Mughals and Nawabs later, for sure, I think, because as mentioned, they do learn Persian, Farsi, they become, I guess for want of a better term, Islamized to some degree. You do see this actually, a lot of Kayastha names in the early 1800s and in the 1700s, sometimes their first names are very Persian and Arabic, actually, but their last name, or they'll adopt titles like Mukhlis, for example, or Omid, for example. These are very Arabic and Persian terms, basically. And I think you still see some of that today in India, but less so than I think in previous generations or so. Because it's hard to to suss out, that this person has this name and it's originally Persian. Does that mean that they were, working for sultans? It's very hard to say these things, it gets it's very complicated. But I think that that's the most consistent story we see historically about Kayasthas, is that they were part of that, I kind of would, for want of a better term, an Indo-Islamic administrative culture, I think, to some degree. They're Urdu, they're, for example, North India, if they, in the dialect, if it wasn't Farsi, they were writing in Urdu. They were not writing in Khareboli or Brajbhasha or anything like that. In fact, there's a story, I think in Malavia actually talks about this story of, or maybe it's in a newspaper, of a Kayastha boy, falls in love with a Muslim woman, basically. And he starts writing so much Persian poetry that his dimak, his mind goes crazy, and he can't get married, so he throws himself down a well for suicide. And the lesson is that, if you spoke chaste Kharebole, this wouldn't happen, basically. So there are kind of criticisms sometimes like that. But I think that's the most consistent. It's their connection with, I guess, the Muslim, not so much religious culture, because, it's fair to say that very few Kayasthas actually convert to Islam. It's very rare, actually. There are some Muslim Kayastha communities, and they're very small, actually. But I would say that their origins, their histories, which is what the questions are getting to, they're very what I'd call Chitraguptian. They are squarely Dharmic, I think, in that Indic tradition, for sure. But that's a good point. Thank you. That's a good question. The next one, can we use the term Kayasthas as a Sanskritized caste? I think they, I don't think they actually, I don't think they become Sanskritized right away. I think they are feeling pressure from what are Sanskritized social reform debates. I think, in terms of the vegetarianism, the debates over their samskaras, what do they wear the janoi, for example, I think these are Sanskritized debates, but I don't think they Sanskritized themselves, actually, because a lot of these culinary traditions, although, I'll say that I think it's also the the way they shift in language, for example, they do move away from Urdu pretty quickly, I think. They move away from Urdu. They move a bit more quickly towards, at least in some public forums, Angrezi and Khariboli, Hindi dialects, basically. So I think in that sense they're kind of Sanskritized, but they are responding for sure to Sanskritized debates that I think anyone who's doing Indian social reform in the late 1900s, late 19th, early 20th century, you can't escape this stuff. I mean, it's part of the public debate. You can't say that our varna rank doesn't matter. We don't care. It actually does, because people are talking about it, But I think that's important because that really underscores the power of the colonial milieu and the colonial state, actually. It's extremely powerful. Shall I go to the next question? Oh, this is a comment. Yeah. Yes. That is the work I think that Rosalind O'Hanlon has published on in sort of the Maratha and Maharashtra, how there's in the time of Shivaji, yes, a Varanasi Pandit is brought over to basically adjudicate the ruling to settle their status. But I think that's an interesting comparison there with North India, because in North India, for example, you still have, like, for example, in the time of Shivaji, you don't have a Muslim dominated political culture, even though they use Farsi. You don't have that political culture that's informed by Muslim rule, whereas in North India you do, I think. So in a way, it's unsurprising in Maharashtra, with a more like, I get, for want of a better term, more of a prevalence of Brahmins, as the Peshwas, for example. This is going to be more important in Maharashtra at the courts rather than in North India. And the Nawabs and the Sultans don't care about this stuff at all. But I think, yeah, that makes sense. And that's very good work that she's done, I think. And I think that's the last comment, yes.
Thank you, sir. Arijit, please go ahead.
Thank you, sir, for your very wonderful and entertaining lecture. So I had like one or two observations to make to this. One would be, sir, like, how do you view Kayasthas as a, how shall I put it? I mean, we should look Kayasthas as a community which, and I mean, its whole trajectory, if we see from the very ancient times, I mean, Kayasthas do reflect in the inscriptions of the early India, so to say, and how, there is a confluence or rather intermingling of two terms, jati and varna, for instance. I mean, where the job and the social position gets into, gets into a connection. So for the Kayasthas case specifically, then I mean, how do you look at colonial law as an instrument of just how shall I put it? I mean, as an instrument of the state to deal with these people who were basically so to say the clerks of India for time immemorial. So I mean, how do you see to the colonial law as just basically what I got from your lecture is just a tool of compartmentalizing people into blocks so that they can govern it much better. And then the second would be, I mean, how do you see ideas of, ideas and social formations within the community? I mean, how do you see their transformations? Just for instance, take the Jats. I mean, the Jats in the Mughal period, they are trying to project themselves as, as Kshatriyas or as Rajputs. And then we come and then the Britishers come, and then they classify them for their own advantages as the martial races. And then we see, in the modern times, we see Jats are demanding, reservations as part of the OBC community. So how do you respond to these changes which are coming from within the community, and how do they influence legal angle, so to say? Thank you, sir.
Sure. Okay. That's great. Thank you, Arijit, for those very thought-provoking questions. Those are very good. Your first point about the law and the colonial state, I think what I see with the colonial state that, the colonial state has many different arms, lots of different fingers, right? And I think some, it's fair to say, are much more intrusive and much more exploitative than others. I think, and so what I say that because I think when you look at how the colonial law, and I'm talking about the civil side, not the criminal side, because the criminal side of colonial law, as we know, is far more intrusive and very exploitative in many cases. But when it comes to the civil side, you know, kind of the less exciting, more mundane, routine stuff about marriage, inheritance, you know, maintenance, things like that. I think here you see an arm of the colonial state that is not as, it's semantically, I think, intrusive by making varna this category that has to be figured out, basically, for the purposes of property, basically. But I think they don't, from what I can see the cases so far, when it comes to colonial law for this, it is not as intrusive, I think, as some other aspects of the colonial state, for example. I think, for example, if you looked at the criminal side of colonial law, just the mere creation of the category of criminal tribes is remarkably like intrusive and exploitative, I think. I think this is much less so, I think, because it's much more argumentative, basically, and liable to contestation rather than, you know, we've decided who you are, and this is what we're going to do with you. You know, just give us a reason, we'll do it. So I think in this sense, yeah, and this is by no means not to downplay the power of the colonial state. You know, like unlike a lot of my colleagues that I got to know and were trained by in Oxford and Cambridge, I tend to see the colonial state as far more powerful in a way, compared to some of my, you know, late supervisors. But I think in this case of law, this very specific aspect of civil colonial law and rank, I think it's much less intrusive in a way, and it opens up much more space, I think, in the milieu for Kayasthas and people who aren't Kayasthas to debate this, actually. And the debate, I think, is very intense. It's just never gotten the attention that, say, you know, for example, non-Brahmin, the anti-Brahmin movement in Tamil Nadu has gotten, for example, or you know, various like caste reform movements like in Western India, like Jyotirao Phule, for example. I don't think this has gotten that attention in the same way. But that gets into the second part of your question, the second question you had about Kayastha formation and what they're doing. You do see some formation amongst themselves during this period, because on the surface, this, you know, the legal stuff, they're clearly trying to present like a very unified front in a way, you know. They are trying to include the Bengali Kayasthas, but at the end of the day, when they go to lobbying for the census, they leave them out to dry. They don't care. But the North Indian Kayasthas are obviously trying to make a very clear category that applies to all of them. But I think what you see when you scratch the surface and then you get into the debates over, you know, consumption, you know, like non-veg, for example, sharab, booze, things like that, you know, you see much more of those gradations and those hierarchies, basically, I think, you know, in a way. You tend to see, for example, I've noticed at the Kayastha annual conferences, you know, the debates over alcohol, for example. It's mainly the higher placed Kayastha subcaste, like the Srivastas, the Saxenas, the Mathurs, for example. They're the ones who are pushing it. They have very, very condescending words and reputations about the Karan and Bhatnagar Kayasthas, actually. That they actually not only say themselves, but they actually reiterate from colonial ethnography, actually. I think they're kind of like replaying it. So I think you see those play out actually amongst themselves. That, well, it's very ironic, like to the colonial state and to the, you know, the British, they're trying to say, no, we're a community. We are descendants of Kshatriyas, right? But when you get back into like within the community, they have all these debates among themselves, basically. And, you know, they try to get these goshchitis, this vegetarianism, it doesn't work, you know, so they quickly give up. And this is being pushed by certain Kayastha subcastes. This is not an ecumenical movement. So I think it's interesting to think about that to outwardly, they want to present a united front, but amongst themselves, they are they're trying to make a formation, but it's clear that there are subcaste categories that don't go away. They don't ignore them, I think, or so, yes. I mean, I've heard I think you really see a difference between like the three higher caste, the subcastes, the Shrivastas, Saksenas, the Mathurs, and say at one end, and then how they view the Karan and Bhatnagar Kayasthas of like Bihari country. There are very big differences, I think, or so. And they're not always very clear. They're sometimes very subtle, I think, or so. Yes. But yes, thank you, Arijit. Thank you for those kind observations and questions. Thank you.
Thanks a lot.
Thank you, sir. Thank you very much. Do we have any more questions?
Oh, there's one.
Yes, sir. There's one. Okay, we'll wait.
Mm-hmm. I think this is very good that this is very good. You have it on the Facebook so that people can post questions.
Perhaps I can read it directly. Just one second, sorry. Perhaps I can read it directly from Facebook.
Sure.
Sir, I want to know to that any influence of legal reform movement of England on debate on Hindu Code Bill debate during 1920s and 1950s. I'm going to post it also here. Just one second.
Oh yes, if I can read it, that would be great. Any influence of legal reform movement of England on the Hindu Code Bill? That's a very good question. I actually don't have an answer. I'm not familiar with that. I know very little about the English legal reform movements. I will say, though, there is one case that I'm trying to think. There is actually one case from 1926, I think, in the Calcutta High Court. And I forget the full names of the parties. The plaintiff's name is Asita Mohan Ghosh. They file a case, it's about Kayasthas' legal rank, varna rank in Bengal, basically. And they don't get the result they want. I can't remember the rough gist of the case, but they actually send it to the Privy Council in London. It makes it all the way to England, basically. And I remember reading the transcript. The Privy Council justices, one of them is actually Indian. His name is Judge Amir Ali. They don't know what to make of this. They're not really quite sure. They basically say we are in no position to adjudicate the varna rank of Kayasthas of Bengal. Like we know that they have been ruled to be Sudras. We know that there's certain scholarship that argues they're Sudras, but they don't really get into that and whatnot. They kind of leave it alone. They don't feel competent to answer that question. But in terms of the influence of India, wouldn't know. But I think what that is a great research question for a new topic to shed more light, actually, or so. I think certainly with the turn that Indian historiography has taken in terms of legal history in the past 15 years, I think this would be a great question, basically. So I hope that someone takes it up, maybe. It would be a great topic to take up, to see, not just colonial law on its own, but is there influence of legal reform in England, in England at the time? Is it influencing, like English barristers and Indian barristers who have experience in England as well and in India? Is this influencing what they think? I think one thing that is really interesting that has been worked on, though, there's a professor, he's retired now at the University of Wisconsin, James Jaffa. He's written on the role of jury trial in colonial India, and he's had some really interesting work that's argued that trial by jury in colonial India is entertained very briefly in the early 1800s, but they decide not to grant it, not to use it in India, whereas that's always been the case in England, obviously. So I think that's also something for further research, because particularly into the modern period, I think that would be quite fascinating to look at, I think, yeah. But I'm sorry for that question. I don't have a direct response for it. Sorry.
Thank you so much, sir. Do we have any more questions? Anybody else? Okay, then I think we should before we go away, I want to inform our viewers that we have another lecture which is offline, and our next speaker will be Professor Eva Orthman from University of Göttingen, and the title of her talk will be Indo-Persian Treatises on Horses, and the date and timing is 30th November 2022, and exact date is 3:30 p.m. according to Indian Standard Time. So I think, so shall I call it off here?
Sorry, please
Uh,
unmute yourself.
Your mic is not.
Yeah, just want to thank Dr. Hayden for this so very interesting discussion. There's so much to think actually of what all was going on in the society in relation to the state and law. And some of the questions have remained unresolved since then, perhaps. And some of the questions are, of course, long-standing, as Arijit was also pointing out. So thank you very much. And maybe when you come to Delhi, we'll meet up.
No, absolutely. Thank you, Professor Akil. I'm sorry I couldn't make it. We had no childcare this week with the bache. It's very hard, basically. But I hope to get out there in March for our spring break, hopefully.
Okay.
Nice to meet you in person. Thank you, Professor Akil, and thank you to everyone for attending. Very helpful comments and suggestions and insights. Thank you very much.
Thank you so much, sir. Thank you.
Okay. Thank you. Bye-bye.
Bye.